faces. Welcome back. The Epstein cover-up has been in operation for years, and I'm about to expose it. This episode is another thread of emails from the newest batch of the Epstein files dataset 12 that was just released. Now, the FBI is very crafty. They have deliberately released these documents in reverse order to try distract and confuse anyone trying to review them. Now, in order to fully expose these emails, I have to read them from back to front, instead of front to back, which is the normal way in English. So let's now read these emails in the correct order, not the how the FBI wanted us to read them. The email reads as follows. Cohen and Gresser LLP, 3rd Amnia, New York, 10022. Christian R. Everdell. July 2, 2021. By ECF. The Honorable Allison J. Nathan. United States District Court, Southern District of New York. United States Courthouse, 40 Foley Square, New York, 10007. Re. United States v. Ghislaine Maxwell, S220 CR 330, AJN. Dear Judge Nathan, we respectfully submit this letter to bring to the Court's attention the recent decision by the Supreme Court of Pennsylvania in Commonwealth of Pennsylvania v. William Henry Cosby, Jr. J. 100-2020, June 30, 2021, in which the Court vacated Mr. Cosby's conviction and sentence because the District Attorney's Office that prosecuted him failed to live up to its express promise not to prosecute Mr. Cosby for the same crimes for which he was later convicted. Ms. Maxwell's case presents a similar situation. As we argued in our supplemental pretrial motions currently pending before the Court, DKT 293, the government has failed to abide by its promise not to prosecute Ms. Maxwell for the offenses for which she was immunized by the Epstein Non-Prosecution Agreement, NPA. We submit that this decision provides support for Ms. Maxwell's supplemental motion to dismiss counts 1, 3, 5, and 6 of the S2 indictment for violation of the NPA. In Cosby, Andrea Constand alleged that Mr. Cosby sexually assaulted her in his residence in January 2004, OP 4-5. Ms. Constand did not immediately report the assault to law enforcement authorities and continued to have contact with Mr. Cosby in the following months. In January 2005, approximately 1 year after the assault, Ms. Constand reported Mr. Cosby's conduct to the police. ID at 6. The Montgomery County District Attorney's Office investigated the allegations, but then, District Attorney Bruce Castor determined that, quote, there was insufficient credible and admissible evidence to bring criminal charges against Mr. Cosby. ID at 7 to 10. Among the factors weighing against bringing charges were that Ms. Constand had waited a year to file her complaint, which diminished the reliability of Ms. Constand's recollections. 2. Ms. Constand's statements about the events were inconsistent. 2. There was a lack of corroborating evidence. IV. Ms. Constand continued to speak to and meet with Mr. Cosby. 1. The opinion, OP, is attached to this letter as Exhibit AEFTA 00010414. Page 2 of 3. After the assault. And V. Ms. Constand had contacted civil attorneys to pursue financial compensation through a lawsuit against Mr. Cosby. ID at 9 to 10. DA Castor issued a signed public statement declining to prosecute Mr. Cosby, which he viewed as, and Mr. Cosby's lawyers understood to be, an agreement that Mr. Cosby would never be prosecuted for the events involving Ms. Constand. ID at 10 to 13, 16 to 18. Believing that he no longer had a basis to assert his Fifth Amendment rights, Mr. Cosby testified at several depositions in a civil suit brought against him by Ms. Constand and made inculpatory admissions. ID at 13 to 15. 10 years later, the successor district attorney, Risa Vale Furman, used those admissions to charge Mr. Cosby with the same crimes related to the sexual assault of Ms. Constand that were covered by D.A. Castor's promise. ID at 18. Mr. Cosby was convicted of those charges at trial. ID at 38. The Pennsylvania Supreme Court held that D.A. Castor's promise was enforceable, and that D.A. Furman's prosecution of Mr. Cosby 10 years later on the same charges violated his due process rights. ID at 78 to 79. As a result, the court vacated Mr. Cosby's conviction. ID at 79. In so holding, the court noted the following. Interactions between a prosecutor and a criminal defendant, including circumstances where the latter seeks enforcement of some promise or assurance made by the former, are not immune from the dictates of due process and fundamental fairness. ID at 55. The same principle applies to Ms. Maxwell's case. As in Cosby, the government is trying to renege on its agreement and prosecute Ms. Maxwell over 25 years later for the exact same offenses for which she was granted immunity in the NPA. Indeed, the principle applies even more strongly in Ms. Maxwell's case, because the NPA was a formal written agreement, as opposed to an informal promise like the one in Cosby. This is not consistent with principles of fundamental fairness. Accordingly, for the reasons already set forth in our supplemental pretrial motions and the principles discussed in Cosby, the court should hold the government to its agreement and dismiss counts 1, 3, 5, and 6 of the S2 indictment. Odin, EFTA 00010415. Thank you for your attention to these matters. Respectfully submitted is Christian Everdell. Christian R. Everdell. Cohen and Gresser LLP, 800 3rd Avenue, 21st floor. New York, New York, 10022. CC. All Counsel of Record by ECF. Odin, EFTA 00010416. Exhibit B. FedEx Express, Subpoena Compliance Group, Litigation Department, 3620 Hacks Cron Road, Building B, 2nd Rocks, Memphis, Tennessee, 31125. Certification of Business Records. The undersigned declare that I am employed by FedEx Express in the legal department as a senior paralegal specialist and custodian of records, and by reason of my position am authorized and qualified to make this declaration. I further declare that the documents are original records, or true copies of records that were 1. Redacted made at or near the time of the occurrence of the matters described in the documents, by, or from information transmitted by, a person with knowledge of those matters. 2. Kept in the course of regularly conducted business activity, and 3. Made by the said business activity as a regular practice. I declare, certify, verify, and state under penalty of perjury that the foregoing is true and correct. Date of execution. Place of execution. FedEx Express, Legal Department, 3620 Hacks Cross Road, Building B, 3rd floor, Memphis, Tennessee, 38125. Redacted. Senior PA Legal and Custodian of Records sworn to and subscribed before me, on this my commission expires. Notary redacted public, in and for the state of Tennessee. Odin, EFTA 00009987. If you have enjoyed this video and the time it takes me review these documents and then bring them to you, then please like this video, share it, and leave your comments in the comment section. Please share this so as many people as possible can hear these messages and hopefully these articles can finally be heard. As always, I will see you next time. Stay safe, stay alert, and stay suspicious.